So the first bill we have before us is House File 60. And it looks like there is a DE amendment. And this bill is going to be laid over for possible inclusion. So Representative Koegel, welcome to the committee. Would you like us to move your DE amendment so it's in the shape you want before our discussion?
Yes, Madam Chair.
Okay, I move the A1 DE amendment. All those in favor of moving the A1 amendment, please signal by saying aye.
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 Any opposed? Okay, the A1 amendment is now adopted. So Representative Koegel, again, welcome. Please tell us about your bill. And again, this will be laid over for possible inclusion.
Thank you, Madam Chair, members. So House File 60 really came about with because of a relationship I built with a constituent over the past few years. I was 2 years ago and I was outdoor knocking and very pregnant. Terry and Alan answered their door and invited me in out of the heat. And we sat down and had a great conversation. And a little bit after the election, they came to me wanting to get some laws changed around notifications. They have and I'll let them tell their story, but basically what this bill does is if there's a child care provider that has had their license revoked and due to some kind of maltreatment and is applying for or appealing to get their license reinstated, this simply just asks that the guardians or parents of that child be able to participate and are made aware of the appeal hearing. And so I will let Terry and Alan share their story with you.
Thank you, Representative Koegel. So the first testifier I have on the list is Terry Rieger. So welcome to the committee. Please state your name for the record and proceed.
Good morning, Terry Rieger, T-E-R-I-R-E-G-E-R.
Please proceed with your testimony, Ms. Rieger.
Well, first off, we'd like to just thank the committee members for giving us an opportunity to present our story. We ask for your support in the changes that we're proposing in HF60. And if you have any questions after we're done, we'd be happy to answer them. And now I'll turn it over to Terry, who has a brief statement for you.
Good morning, and thank you for having us. This time of year is pretty difficult for our family. Next week, it'll be 3 years ago that our grandson, who was then 4 months old, was rushed by ambulance to Masonic Children's Hospital in Minneapolis and was diagnosed as a shaken infant. An investigation began with the Sheriff's Department and Child Protection. And based on the chain of custody, the nature of his injuries, and statements that were given, it was determined that our grandson was hurt while he was in daycare. Part of the investigation was an immediate suspension of the daycare's services. She filed an appeal of her closure, and that was heard before an administrative law judge. We've been able to get a copy of that order as well as the transcripts of that hearing. A lot of the information that was given during that hearing was inaccurate regarding our son, his wife, and his children. Our son and his wife were shocked to learn that this hearing had even taken place. They weren't informed, they weren't invited, they found out about it after the fact. And had they been notified of this hearing, they would have attended and been able to provide information that may have affected the ruling that the administrative law judge made. In his ruling, he noted that the parents were absent, and so he was only able to make a ruling based on the evidence that was presented, and the daycare was allowed to reopen, and she is in business today. So we're asking that language be included that parents of children who are maltreated in daycare homes are notified of the hearings if a provider is appealing their closure, so that they're given the opportunity to present all sides of the story. Thank you.
Thank you for your testimony, Mr. and Ms. Rieger. And My condolences, and so sorry you had experienced that with your grandson.
Thank you.
So Representative Koegel, do you have anything to add to this? Otherwise, we'll open it up for questions.
No, I'm willing to. I just do want to add that Terry has texted me pictures of her grandson, and he's adorable.
We like him.
Are there questions from members? Representative Pinto.
Thank you, Madam Chair, and thank you to the testifiers. I'm so sorry to hear about your experience. It's just awful. And I actually had a question just relating to the bill, just to clarify that although the situation involved the child care, it seems like from looking at it and looking at this section of law that really would apply to all situations where there's licensing for DHS. And I guess I'm interested in particular that it is broader than childcare. The Early Childhood Committee focuses on childcare in particular, but it seems like this really is broader. I just want to make sure to verify that.
Representative Koegel.
Thank you, Madam Chair. And I know DHS, I worked with DHS on some technical assistance. And so I do believe they're here. It looks like Ari is on the call as well.
So let's see, DHS. Ari Didion, are you here, or Autumn Baum? If so, can you answer Representative Pinto's question?
Yeah, I can answer that, Madam Chair. Madam Chair, Representative Pinto, my name is Ari Didion. I am the Legislative Coordinator for State Government Relations at DHS. We met with Rep. Koegel to kind of talk over her intent on this bill. And so the DE amendment kind of addresses the original bill was a bit broad. So generally what the amendment does is it removes changes to the sections on temporary immediate suspension hearings and fair hearings and focuses on contested case hearings, which would be the ones that go in front of an administrative law judge. Because first of all, with the and then the language that we suggest instead goes into the Maltreatment of Minors Act and mirrors language for contested case hearings that's currently in the Vulnerable Adults Act. So we removed temporary immediate suspension language because this type of hearing, this would not be the kind of appropriate time because the maltreatment investigation is still often ongoing and this is not the final licensing action. Specifically to Rep. Pinto's concern about this being broader than just childcare, that's part of the reason we took out the section relating to fair hearings, because those are maltreatment hearings more generally. So that would also apply to maltreatment that did not occur in a licensed setting. And so in the original bill, sections 2 and 4 focused on contested case hearings. These are the ones that are heard by an administrative law judge. And so we put language that's similar to existing language in the Vulnerable Adults Act here in the Maltreatment of Minors Act. So essentially it strikes everything. And sorry, I'm getting a message from. And so also that this section applies to all license programs where there has been a licensing sanction. Does that answer your question, Rep. Pinto? Thank you,
Ms. Didion. Representative Pinto?
Thank you, Madam Chair. I guess, no, it maybe doesn't exactly answer my, I guess I had kind of the opposite concern. I'm just trying to figure out if this is specific to childcare only, then I guess it's a jurisdictional issue, just that we may need to talk about whether it needs to be heard in the Early Childhood Committee. It seems like though that it is broader, and so that's not an issue. It's really going to licensing more broadly. So if somebody can just clarify, perhaps as Ms. Didion, at this point with the changes, specifically what kinds of situations does this apply to?
Ms. Didion?
So this would apply to hearings for for license programs where there has been a licensing sanction due to a maltreatment finding. So it would not apply to licensing actions that aren't related to a maltreatment finding. But I don't believe, and we can follow up and get back to you on this, but I don't know that it's limited just to childcare, but it would typically be childcare in this type of hearing.
Representative Pinto.
But we can get you a list of licensed programs this would apply to.
Thank you, Madam Chair. I'm seeing perhaps Ms. Sunderman may have been making a gesture to provide help. I will note it does make sense to me this could apply, for example, to foster care situations where there could be a maltreated minor. So I guess I would think that it would be broader, though maybe more commonly in childcare, but could apply to foster care and other situations. But perhaps, yeah, Ms. Sunderman or somebody else, Madam Chair, can help with that.
Sure. Ms. Sunderman, would you like to comment?
Sure, Madam Chair, members. Representative Pinto, this does apply more broadly than to just childcare facilities. It would apply to a licensing sanction based on a maltreatment determination for any DHS licensed facility that serves children. So since it's child maltreatment, so it would apply more broadly. Although in reality, most of those are going to be childcare, but there are a broader swath of facilities that this would apply to.
Thank you, Ms. Sunderman. Representative Pinto, does that answer your question?
It does, Madam Chair. Thanks very much for indulging that. Appreciate it.
Thanks, Representative Pinto. Representative Albright.
Thank you, Madam Chair. And our hearts go out to the Rieger family for their circumstances. As a parent, I can only imagine the heartache that you have gone through. So please let I hope you know just how we feel for you. Madam Chair and Representative Koegel, I'm going to add on to Representative Pinto's concerns and or observations about this bill. As I look at the DE1 amendment, candidly, Madam Chair and Representative Koegel, you have materially changed the outlook and the scope of this bill that you're bringing before us today. And so, Madam Chair, I'm just wondering, and I'm curious why, without further delay, you would not amend your motion possibly to include not only Representative Pinto's subcommittee, but also candidly a judiciary for the purposes of the courts and civil proceedings that would pertain to this. You mentioned in your earlier conversation about that we are to limit our scope to certain issues, whether they be policy or finance, but candidly, that's why we take a look at both of those. And in the context of this bill, when it has so materially changed, I might suggest that we allow and avail other committees of your choosing or direction, particularly the ones I've already cited, that would have an opportunity to vet this DE1 amendment particularly, and before it comes back to this committee for possible inclusion in the omnibus bill. So observations. Thank you, Madam Chair.
Thank you, Representative Albright. My comments pertain to the next two bills we're going to hear. This is we're giving this a full hearing today. Representative Liebling.
Well, thank you, Madam Chair. I do sit on the Judiciary Committee, and I don't think that the Judiciary Committee would have jurisdiction over this. I mean, I suppose that after this bill's laid over, the chair could check with the chair of that committee, but this is an administrative hearing. It's not a civil action like a civil action in a court. So I think there is a difference there. But my question is, and I should say, I think we just resolved the issue about jurisdiction in Representative Pinto's committee too. So I think it's quite properly in this committee and quite ready to be laid over. But my question really was, I'm so surprised that we don't already do this. And I guess I don't know a ton about the way these administrative hearings work, but Representative Koegel or maybe someone from the department sort of, why wouldn't we already be doing this? It just seems so strange that we don't allow this kind of participation in these kinds of cases. The judge, I'm sure, can limit you know, and control what goes on, but to not take any sort of input from the family just seems really like you would have half your information missing. So I'd love to just hear just a bit more about that. Thank you.
I agree. I was surprised to find out. We would like to know from Ms. Didion, or maybe Representative Koegel can add to that too, what the current practice is if we're not contacting individuals to be notified about these proceedings. So Ms. Didion, can you help us inform us of what the current practice is?
Sure, Madam Chair and Representative Liebling. I will say that because these are hearings that are heard by the Office of Administrative Hearings, our role as the agency in these is somewhat limited. So I think that in some cases, parents are called as witnesses, but I wouldn't be able to speak to specifics on that. Someone from the Office of Administrative Hearings might be able to speak to that, or I can check back with some folks here in legal and get you more information about that.
Thank you, Ms. Didion. That would be helpful. Representative Koegel?
Thank you, Madam Chair. And I guess that was exactly why we brought this bill, is because, you know, when Terry and Alan contacted me, it was kind of hard to believe how this all went down. And so, and I really want to, you know, thank Terry and Alan for making sure that this stayed on the forefront of my mind. It wasn't until, you know, I'd heard their story 2 years ago, and then over the summer, Terry had mailed me a letter, and you know, just to remind me that this is, you know, this is still going on. And so, you know, she really kind of lit a fire under me, and I'm just so grateful that, you know, they're continuing to work on this. And so that's exactly why I wanted to bring this bill forward. I don't think it's like, you know, it's not a crazy thing to ask. And so I think it's a really reasonable ask that, you know, at least families be able to participate when, you know, their child has been maltreated.
Thank you, Representative Koegel. Representative Liebling, did you have a follow-up? No. Representative Albright, your hand is raised.
Thank you, Madam Chair. I did have a follow-on question for either Ms. Didion or to Representative Koegel. And as I look at the DE on line 1.8, and then concluding on 1.9, it talks about that the notice must be sent by certified mail. And then in lieu of that, on 1.16 through 1.18, if the agency is not reasonably able to determine the address, the administrative law judge is not required to send a hearing notice under that. I'm just wondering, it seems fairly narrow in terms of the only avenue for a notification being attempted to the parents. And I'm wondering if the author of the amendment and the bill would consider including whether you know, how many of us obviously are on social media, whether that be through Facebook, Twitter, LinkedIn, where you can know where they are working. And so in terms of proper avenues or potential avenues for notification to the parents, I'm wondering if we're limiting it too severely to just certified mail, and that if we're really truly trying to get a hold of the parents, that we might not also include other avenues, whether that be just the old simple telephone or have the ability to search for those parents through other means. Trying to help the parents here with my discussion.
Thank you, Representative Albright. I think we need to be cautious of using social media. You don't want to contact the wrong person and give out private information. But Representative Koegel?
And thank you, Madam Chair, and Representative Albright. That's exactly what I was going to say. I think, you know, we need to make sure that there are some privacy protections, and certified mail is one way to guarantee that it's coming from the right people and going to the right people. I would, you know, if email or phone calls are something that we can do, you know, I would definitely I would entertain that. But I think, you know, just as far as privacy concerns, I think that's probably where DHS was coming from. I don't want to speak for them, but you know, that was the language assistance that DHS helped on as well.
Thank you, Representative Koegel. Representative Albright?
Madam Chair, just to follow on to that question, I'm wondering if DHS would weigh in terms of the inclusion of to Representative Koegel's suggestion about a couple of other forms that would also safeguard the privacy of the individuals.
Ms. Didion?
Thank you, Madam Chair. Representative Albright. Again, I'll just note that our ability to speak to that bit is a little limited because this would be handled by the Office of Administrative Hearings. So what I can say is that this language was written to mirror existing language in the Vulnerable Adults Act. So that is part of why we chose that. I'll also say that we did share technical assistance with the Office of Administrative Hearing. That's why the amendment has the lead investigative agency, whether that be DHS or the county, providing the parents' contact information, because we are a bit separated from those hearings, and that's kind of for good reason. So, but we might be able to get back to you more on that. We have been running this by the Office of Administrative Hearings as we've been working with Rep. Koegel on this.
Thank you, Ms. Didion. And I'm assuming if there's maltreatment cases, we should have pretty valid addresses for these parents or family members or caregivers or guardians. Representative Koegel, do you have any closing comments?
Thank you, Madam Chair, members. I really appreciate the opportunity to present this bill, and I'm again just so thankful for Terry and Alan for bringing this forward. And this just seems like the least we can do. So, and I really want to see more pictures of the grandson. Thank you, members.
Thank you, Representative Koegel, for bringing this forward, and thank you, Mr. and Ms. Rieger, for being here with us today. We wish you all the best with you and your grandson for good health in the future.
Thank you very much. Appreciate it.
Okay, so this bill will be laid over for possible inclusion in the Human Services Finance Bill.